that in light of the disclosure about the relationship between Justice Murima and the Speaker of the Senate, we find ourselves in a very unfortunate situation where the bench looks like it's on trial. Motions of recusal are normally very difficult to prosecute because the question is, and this is a question that respectfully I want to pose to the bench, will you feel comfortable? Do you appreciate the fact that so far the events that have taken place, whatever determinations that you will arrive in these particular matters, and they are weighty constitutional national matters that affect the entire country, are you satisfied that they will be received well by the public? That's a question that should be in the mind of the judges as they decide whether to recuse themselves or not. Secondly, it is very clear that the only mistake here was that Justice Murima did not disclose a relationship between himself and Amason King, which is an act of a friendship and which is not even illegal. But disclosure, the mere fact that there was no disclosure, by itself creates suspicion, apprehension in the minds of the applicants. The last question is, if Justice Murima decides to recuse himself, is it the entire bench that will recuse itself, or only one judge will recuse himself? Because I'm convinced that inevitably Justice Murima must recuse himself. Thank you so much.
Your Lordship and my lady, if it may please you, my name is Akimpa. I do appear for the third petitioner in the consolidated petition. Your Lordship, mine is just to put into context the Supreme Court decision in Dari and 5 others versus East African Development Bank. So, Your Lordship, in that particular matter, I want to state that, first of all, it was before the Supreme Court, and notwithstanding the doctrine of necessity, the Supreme Court considered that the right to a fair hearing by an impartial tribunal was so sacrosanct that the Supreme Court did not even consider the doctrine of necessity. So I just want to read paragraph 26 where the Supreme Court said, what is undeniable is the fact that by resorting to this cause of action, the applicants are unequivocally accusing this bench of lack of impartiality, fairness, and integrity. Such an accusation against a judge goes to the very core of his oath of office. Coming from a party to ongoing proceedings, such an allegation must strongly persuade the judge to recuse themselves. So that is what the Supreme Court said. So, Your Lordship, in that particular paragraph, the Supreme Court is saying that if there is an allegation, especially because this instance is actually almost same to that, because there was a complaint that was lodged against that bench before the Judicial Service Commission. I have heard today that the first petitioner has already lodged a petition before the Judicial Service Commission. Your Lordship, I beg that you are guided by this decision in holding that the right to a fair and impartial tribunal is very key.
Thank you, but I think you should let us know about the petition which has been lodged, because I don't think parties are aware of that.
Your Lordship, I think it is in the further affidavit.
A petition?
No, not petition.
What is it?
A complaint that was
Don't mislead the public. There's a whole difference between a complaint and a petition.
Yes.
Don't mislead the public.
He's the one who has said petition.
All right. Yes.
May it please the court. My name is Dr. Eboso. I'm from Vihiga County, and I'm petitioner number 11 in the consolidated petition in the cohort 1. As I sat as a petitioner who essentially had no issue with the sitting of the bench, because when a petitioner files a petition, there is a presumption that the bench is properly constituted, and that Kenyans elected the Constitution of 2010, and in it provided the independence of the judiciary and the conduct of the expected conduct of judges. And therefore, we as Kenyans have trust in the judiciary and the individual judges at the time when they are appointed and during the course of their performance of functions. But as I sat, I agonized over the issues that have been raised, and at the outset, I realized that the recusal application has been made to this bench to recuse itself, or some of the judges to recuse themselves, but as a decision of the bench. And I agonized over whether recusal proceed or the place of recusal proceedings in a setup like ours. And perhaps this was amplified, the back and forth that we saw with regard to the facts that were coming out. And I would wish to be persuaded by Dr. Haminwa that really recusal proceedings and the kind of facts that come to light ought not really be a subject of litigation for several reasons. One, recusal proceedings are really against individual justices, and they relate to the personal conduct which really lies in the mind and conscience of the individual judge. I would give an example. Suppose we ask the bench for one of the judges to recuse themselves, and two of the justices disagreed with the recusal, but the very judge who we are asking to recuse themselves. Would we then say that this bench has ruled that the judge must sit? So it's really an individual decision of the judge to reflect upon the facts that are before him, the relationship that is being alleged, because why it can't be litigation, and it should be in the interest of all the parties that the judge is not biased, such that when you make it litigious, what happens is one side will be claiming the other side must prove a point, which they are not really very materially cognizant of. And it's really just the judge who knows the actual facts of the issue. And so it really is upon the judge individually to look at themselves and ask themselves whether the facts that are being alleged constitute what would amount to a bias. And when we make it litigious like this, we actually violate the Constitution for the reason that the conduct of a judge is not meant to be subject of any proceeding before a court. That is a matter that should be before JSC, that should be before other tribunals. And the Supreme Court has told us that in Bellevue, that the conduct of a judge, because that's what is being alleged here, a judge is being alleged to have concealed information that they ought to have given. A judge is being alleged to have abused office by sitting on a particular day and whatnot. So those are things that really should not be a subject of a proceeding if we really intend to proceed with this matter. Suppose this bench does not recuse itself, then how does the matter proceed in that manner? I'd like to point out that I think I've already talked about the fact that the facts relating to a recusal, the person who really knows what those facts are and the extent to which they are is the judge. And so any discussion as to whether we've proved a case or not proved a case is neither here nor there as relates to this issue. I'd like to refer the court, I don't know how we quote precedents, but I'd like to refer the court to a decision of the Supreme Court of the United States in Jewel Ridge Coal Corporation versus local number 6167, United Mine Workers of America in 1945. And there the court, the Supreme Court, found that I think one of the parties was asking for the entire bench to recuse themselves. And I'll just take maybe one more minute for the entire bench to recuse themselves. And the Supreme Court of the United States found that that decision cannot, a question of recusal should be directed at the judge, and it should be the judge to make the decision whether we themselves will recuse themselves or not. It was also, again, captured in 1980 in a decision called Hanrahan versus Hampton, still at the United States Supreme Court. And in India, in 2016, Advocates on Record Association and others versus Union of India. Justice Madan also pointed out the same. And finally, I'd like to refer the court to the fact that this is a sensitive matter, but is also, as sensitive as it is also an urgent matter, as considered by the bench and as considered by everyone. That there is the aspect of necessity that this matter must be heard. And there's also room for appeal should any person feel they are aggrieved the judges herein. And so what I would say is that I would ask that the individual justices that you look into the issues that have been raised, you look into the facts which you are familiar with them yourselves, and go home and reflect whether indeed you will have the impartiality to hear this matter. And once you make that decision, let's hear the matter and proceed. Thank you.
My lords and my lady doctor, if it pleases you in the matter, my name is Wamboi, Shadrach Wamboi. I speak with the blessings of my senior, Mr. Danstan Omari and Samson Nyaberi, on behalf of the 9th petitioner. My lord, at the very outset, permit me to submit that this court has a duty, either individually or as a collegial bench, to hear and determine the matters that are presented before court. Indeed, just like any other person, you have a duty to act in the defense of the Constitution. However, matters that relate to the calling to question of the conduct or the integrity of the bench or a judge are matters that are characterized in this country with a lot of rage, as we have even seen being demonstrated in this honorable court. In other occasions, applications for recusal, my lady and my lords, are said to be a dialogue of the deaf and a dance of the blind, to the extent that the petitioners or the applicants making an application such as the one that finds itself before you sometimes refrain from even saying the very grounds upon which they make the application, as you have seen before this court. And again, the bench on the other end, on many occasions, tends to draw conclusions of what they will think the applicant is saying about their conduct or their integrity. So for that reason, my lady and my lords, the court is then called upon to reflect as to its duty to do that which is just vis-a-vis the perception, either actual or apparent, that will flow or be submitted by applicants who call to question the conduct of the court. My lady and my lords, permit me to also make a contribution with regards to the decision that has been made in the Supreme Court case of Dari Limited. And there is something that is important that we must highlight. In this application, the Supreme Court was not called upon to adjudicate on an application for the recusal of the court. That was not the application that was lying before court. What is important that we must underscore in this case is that the court was invited to suspend or stay its proceedings in view of a complaint that had been made by the applicants before the Judicial Service Commission, so that the court ultimately ended up recusing itself, not that it had been invited to recuse itself, but because there had been a complaint that had been filed before the Judicial Service Commission. My lady and my lords, the reason why the 9th petitioner rises in support of the submissions made by counsels who have made the application is largely due to our duty as the officers of the court. And we have seen in the application in petition number E015 of 2024, annexure marked DMM2, which is a letter address to my colleague Mr. Swanya of Swanya and Company Advocates from the Judicial Service Commission, highlighting a complaint that has been made by the Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua, against this honorable bench. So, my lady and my lords, as I rest, the question that begs the answer is simple. If a complaint has already been lodged against the persons of this honorable court, how will a reasonable person, or will a reasonable person out there be confident that this court, in light of the complaint that has been lodged against you by one of the petitioners, arrive at a just finding in this case? My lady and my lords, that should mark the end of my submissions. I shall pave the floor for the remaining minutes to my seniors to also speak some wisdom to what is in issue. Thank you.
My lady and my lords, my name is Sam Nyaberi, for the 9th petitioner in the second cohort. I stand in support of the motion for recusal, and I juxtapose it in this manner. Recusal applications are tantamount to the court being on trial. It's a charge sheet for the court that it then will determine the parameters that have been set and the grounds that have been adduced to find or make a finding whether they merit. And in so doing, the court will not be given an opportunity to make submissions as we are doing. It's the court that is going to now render a ruling. Then the big question that we ought to ask ourselves, whether then the court is going to rebut on the heavy submissions that have been made, because going into the second room of going to analyze what the petition is all about will mean that we as the petitioners will have faith in even opening the second chapter of the proceedings as they are going to happen. So therefore, my lord and my lady, the point we are making is, kindly, there is enough evidence that has been laid before you to make a determination that the court to open the second chapter of going into the determination of the petition. I rest my case there. The balance of my time, I invite Omari to finish up and conclude.
My lord and my lady, man, be very, very brief. One, the court, in determining whether the DCJ has powers to constitute a bench, made a finding that the petitioner was found guilty of an offense of addressing the gallery. His lawyers, all of them, never addressed the court. The lawyers were not addressing you. It is the petitioner who was addressing you. You have already made a decision that the petitioner is addressing the gallery. Will he have confidence to appear before him? Ahmed Nasir Sr., when he was constantly spotted by the Supreme Court that he was attacking the courts, the court decided to punish. When he appeared, all the members of the Supreme Court recused themselves. They never gave him audience. Will the Deputy President have audience before you when the main substantive motion comes before you? You have already made up your mind that his job is to address the public. The rationale for this matter, going live and my brothers and sisters saying it is a public interest matter, is because 55 million Kenyans are waiting to see the free learned judges appear impartial. It is our submission from our client Sharia Mtaani that based on that, you recuse yourself. I'll give a small analogy. When I went to pay dowry for a friend of mine, we were told that that place, those people were witches. So that religion, when food is being prayed for, you must close your eyes. We never closed our eyes because behind us we feared, my Lord and my Lady, that these guys might destroy us. The petitioner is scared of this page. That's my Lord.
Are we through with all parties supporting the application? In that case, Professor, you can continue.
I thank you, my Lord, and members of the bench. I will try to be brief. My colleagues and I, I think, would like to be truthful. First, we would like to begin by observing that today is the 10th day since this bench was constituted. It was constituted on the 14th of October. There were petition 522, petition 550, petition 569. Nobody ever complained at all until we came here on Monday. And even then, the complaint was an ambush. The petitioners appeared before my Lord Judge Ogola on the 16th of October. Orders were made in their favor. They were extremely happy. No complaint. The three judges of this bench were in the bench in 522 of 2024. No complaint. This complaint is a complaint founded on the fact that on the 18th, the Honorable the Attorney General, for the first time, also got orders. Now, that is when this bench became a bad bench. It was a very good bench for as long as it gave any order to the petitioners. It became a suspicious bench when it gave an order, only an order to expedite the hearing. The Attorney General had wanted many things. They were all declined. I will address you, my lords, on the understanding that we have two petitions. There's one petition I call the Kerugoya petition. And there is another petition I will call the Nairobi petition. It is our preliminary submission that yesterday's ruling of the 23rd substantially addresses the issues raised in the Kerugoya petition, and that those issues are now the res judicata. There is issue estoppel. There is issue estoppel, a doctrine of law that states a question that has been resolved by the court cannot be litigated afresh in the same proceedings. It is are contained in a document that bears my signature, but that is not for me to say. So let us proceed to the two other allegations. At one point, I was very surprised to hear a submission that said that my Lord Justice Ogola is close to his wife. How can that be? How can that possibly be a bad thing? But a further extension of that argument was equally spurious. A professional person a professional person is entitled to an independent professional existence. Be it the husband, be it the wife, be it siblings, be it children, they have independent professional, and I am shocked that that can be a ground. Another ground now made is that the Honorable Justice Murima is a friend of the Speaker of the House. The Speaker of the House was my student. I don't know whether I should recuse myself. My Lord, if I may say this with respect, I have been a law teacher for 38 years. I apologize that that's not very long. There are 3/4 of the lawyers under the age of 50, I have taught them. I don't know whether I should recuse myself each time I appear against, including the Honorable Tom Ojienda here, Senator. Could you confirm that?
I confirm that you're my teacher.
And John Morogaru, Senator, is a member of the legal profession. How else are we to do our work? Paul Kibugi Muite, Senior Counsel, a personal friend for many years. On the day I got married, he brought me a copper coffee dispenser. Am I never to do any case with him? Should I always tell people, I know Paul Muite from when I was in, he brought me a gift? It cannot possibly be. That is not how this profession works. Let me very quickly set this, what I believe, we believe, is the standard. The standard is set in the case of the most important of this all, is the right case which has been talked about. When will you ask for a recusal? And I agree with Dr. Kamino when he says that no lawyer, no advocate should ever make an application for recusal lightly. Indeed, an advocate approached by a client who is making personal attacks against a judge that are baseless must return the brief to the client. That is the honorable thing to do. Now, I have referred you to the right case, but the most important of this all is the Rawal case. In the Rawal case, which you are aware of, Rawal versus Judicial Service Commission, the court says there is no basis for a judge to automatically recuse themselves when a bare allegation is made by a party. The allegation must be substantiated. First, I have not come across any authority in support of the proposition, and Dr. John Kaminwa did not provide any. On the contrary, decisions abound that judges must not recuse themselves on flimsy and baseless allegations. It is our submission that a claim that the friendship that may, because they went to the same school, because they went to the same university, because they come from the same county, that is baseless. It must be demonstrated, like was said in the case of Kaplan and Stratton, versus Z Engineering Construction Limited. If disqualifications issues were to be raised, say, because a judge and a member of the bar belong to the same Rotary Club or the same Lions Club or the same sports club, there would be no end to such approaches. There would be no end. In this case, it has not been demonstrated that there is any way in which the independence of any of the judges here can be said to have been compromised. Let me say something relating to the Derrick case, because I was involved in that case, again with my very good friend, the Honorable P.K. Moite, on one side, and my friend Paul Nyamodi. They were on one side, I was on the other side. I think that's why Mr. Nyamodi has now come back to my side, because we were the successful party in that case. And as one of my learned juniors here on the opposite side has stated, you know the context of the Derrick case. Because at paragraph 24, the court states this: the appellant's applicants herein are seeking a stay order from this court in the most unusual, strange, and dare we say disingenuous strategy. What had they done, my learned friends? We had litigated for a very long time. Litigated in England in the High Court, litigated in England in the Court of Appeal, litigated in the High Court here, litigated in the Court of Appeal here, litigated in the Supreme Court, and their final card, they had made a complaint against the Supreme Court. And what they were asking the Supreme Court to do is stay proceedings the allegations we've made against you. And I think the Supreme Court threw the sink at them. And that is why the decision says what it says. Now, I want to wind up by saying that if this court were to accede to this application, it would throw a critical public interest when the country is in the throes of a serious constitutional crisis. And that is why philosophers like Dr. Muthomi say